afternoon, good evening, ladies and gentlemen. My name is Perry, and I'm pleased to be one of the moderators and your MC today. Thank you all for joining us for our very first SIAC Africa webinar. I would first like to introduce SIAC CEO, Ms. Lim Seok Hui, to give some opening remarks. Ms. Lim, please.
Okay, thank you. Good afternoon, good morning, and welcome, everyone. Thank you all. Thank you to our speakers, our supporting organizations, and all of you for taking time midweek to join us at today's event. And it's a very special event because it's our very first, it's our inaugural SIAC Africa webinar. I remember actually about a year or so ago, we had a series of Users Council meetings with our African Users Council members, and a fair number of whom are here today with us. And we talked about what we could do in Africa. We wanted to learn more about the international arbitration landscape in Africa. And we wanted to find out what users in Africa look for, the key factors, when they choose a seat, an arbitral seat and an arbitral institution. So the culmination of those discussions, the very, very helpful feedback from our Users Council members, and careful planning by the team, including especially Perry, is today's event. So it's a virtual one, and we hope that the next one hopefully will be an in-person one. But still, I hope that this program we've put together for you will give you an introduction and some helpful insights into the inner workings of SIAC, our rules, our procedures, and our people. Africa is important to us. In the last few years, we have seen increased interest from users in Africa and a steadily growing number of African parties at SIAC. Africa's key trading partners and investors, such as the US, India, China, Europe, the Middle East, and ASEAN countries, including Malaysia, Indonesia, and Vietnam, are the top foreign users at SIAC. Recent developments in Africa, such as the African Continental Free Trade Area, are expected to further increase the level of trade and investment activity in the region and attract global investors to the continent. With the increase in cross-border commercial activity, companies, investors, and businesses will need an effective dispute resolution mechanism. International arbitration ticks those boxes by providing a neutral forum, expert arbitrators, and an enforceable award that can be recognized and enforced worldwide in 168 jurisdictions at last count under the New York Convention. This year, SIAC celebrates its 30th anniversary. I'd like to share some recent developments. In the 2021 Queen Mary survey, Singapore ranked for the first time jointly with London as the most popular seat in the world and is the most popular seat in Asia Pacific. Although parties are free to choose any jurisdiction as a seat when they choose SIAC, Singapore, with its trusted legal system and its pro-arbitration world-class judiciary, continues to be a popular choice. Also in the 2021 Queen Mary survey, SIAC was ranked the most preferred arbitral institution in Asia Pacific and second among the world's top 5 arbitral institutions, behind the ICC. In terms of caseload, last year, 2020, saw SIAC set a new record with 1,080 new case filings. It's the first time we crossed the 1,000 case threshold. 94% of our cases filed last year were international cases. To put these numbers in context, the 1,080 figure included 2 large sets of related cases that amounted in total to about 400. But even if we were to leave aside these 2 large sets of cases, we would still have had well over 600 cases, and that would have been a significant increase from 2019. I'd like to touch on SIAC's people, the cornerstone of SIAC. We have benefited greatly from the wealth of experience, the illustrious stature, and the deep specialist knowledge of our board and our court members. We have a talented, multinational team of experienced lawyers in the Secretariat who are qualified in multiple jurisdictions, and they perform our case management functions, and they can administer arbitrations in several languages. The SIAC panel of arbitrators is comprised of over 500 expert arbitrators from 40 jurisdictions, including African arbitration experts. And we are looking to expand the SIAC panel to include more leading African arbitration practitioners and arbitrators. We have, as I mentioned earlier, an African Users Council, and we intend to work more closely with them to organize and plan training programs and initiatives for African lawyers and students to further promote international arbitration in Africa. We have an African representative on the Young SIAC committee, that's Isaiah Bhagamo, who's speaking on today's panel. Young SIAC aims to nurture young arbitration practitioners as counsel and as arbitrators by giving them speaking and networking opportunities. I'm pleased to say that as Young SIAC is one of the largest, I think at last count is over 6,000 members, and definitely one of the most active young arbitration practitioners groups in the world. SIAC is committed to providing world-class case management services. We constantly seek to enhance the quality of our offerings. We are currently revising our rules from the 6th edition, moving on to the 7th edition, to further enhance the timelines, to take into account recent developments in international arbitration practice and procedures, and to better cater to the evolving needs of our users. What we try to do is constantly to be innovative and to be nimble and responsive to our users. And so a key part and a key role that the Users Council plays is also to share with us their feedback, and we consult extensively with them when we revise our rules. Our latest overseas representative office in New York, together with the other overseas offices in India, China, and South Korea, are an integral part of our continuous efforts to deepen and broaden our engagement with users and stakeholders in the global arbitration community. Turning to the pandemic, the increased use of technology and virtual hearings has had a leveling effect. It has put us on a level playing field with other institutions in Europe and elsewhere in the world by bridging geographical gaps. As part of our efforts to stay engaged with our users globally, we took everything online from last year, and we continue to do so this year. That includes our International Arbitration Webinar series, our SIAC Academy program of training courses and initiatives, our SIAC module with universities both in Singapore and around the world, our Young SIAC events and initiatives, and today's event. The global upheaval triggered by the pandemic has sharpened the focus on the key factors that users consider when they choose an arbitral institution. And those are neutrality, independence, integrity, efficiency, transparency, and importantly, political stability. These are core values that SIAC will continue to uphold and promote. We want to do much more in Africa, and we look forward to deepening our cooperation and our engagement with users and friends there in the community to jointly promote international arbitration. Thank you.
Thank you, Sir Hui, for the wonderful opening remarks. I'm very pleased to now introduce today's panel to you, titled Effectively Managing International Arbitration Disputes, the SIAC Advantage. We have joining us today, Ms. Funke Adekoya, SAN, a founding partner at ALEX. She heads the Dispute Resolution Practice Group. Funke has over 45 years of experience in litigation and arbitration. In the field of arbitration, she represents both local and transnational parties as counsel in domestic and international arbitration proceedings within Nigeria and abroad, and has also acted as arbitrator in numerous proceedings. Also based in Nigeria is Mr. Isaiah Bozimo, who is a member of the YSIC committee and a partner at Broderick, Bozimo and Company, a niche arbitration and litigation firm in Abuja. Isaiah has represented state-owned entities, corporations, and high net worth individuals as counsel in complex disputes involving energy exploration, power purchase agreements, construction of major infrastructural projects, financial services, and has also served as arbitrator in several disputes. Ms. Elodie Dulac is a partner at King & Spalding Singapore office and a member of the firm's International Arbitration Group. Elodie has represented clients in commercial and investment arbitrations around the world. In addition to her work as counsel, Elodie has been appointed as arbitrator in HKIAC, ICC, SIAC, AIAC, KIAC, and other ad hoc arbitrations. Ms. Medan Kime, the founder and principal director of iResolve, is an advocate, arbitrator, accredited commercial mediator, and dispute resolution specialist. She has substantial experience with TR, NCC, ICC, CRICA, and Untitled Rules. She has acted as counsel in arbitrations, as well as arbitral secretary in numerous arbitration matters. Ms. Ruben Mukamboa, a director at J. Miles & Company, is in the unique position of having experience as a lawyer in both Singapore and Kenya. She is a dispute resolution specialist, having represented clients at various levels of the courts in Singapore and before arbitration tribunals in SIAC, LCIA, ICC, and ICSID. And last but not least, we have Mr. Kelvin Poon, who is the Deputy Head of the International Arbitration Practice Group at Raja and Tan Singapore LLP. Kelvin has represented clients in a broad range of construction, commercial, and insolvency disputes in the Singapore courts and also in numerous arbitrations. The panel will be moderated by Mr. Kevin Nash, Deputy Registrar and Center Director at SIAC, and myself. Since joining SIAC in 2012, Kevin has overseen the administration of thousands of international cases under all versions of the SIAC rules and Untitled Arbitration Rules, amongst others. So diving straight in, thank you all once again for joining us today for our very first SIAC Africa webinar. We are so excited to have esteemed arbitration specialists from Nigeria, Kenya, Tanzania, and our very own Singapore to discuss the practice of resolving disputes through international arbitration in Africa and Singapore. As we have limited time today, we will try to cover as much ground as we can, and we would also love to hear from you. So if you have any questions, please send it to us through the Q&A function. So I'd just like to pass the time over to Kevin now to give you a brief overview of SIAC and our popular mechanisms.
Thanks, Perry. I think it's noteworthy that Perry is heading up our African initiative, so please do get in touch with Perry if you're interested in doing any of our information exchanges with respect to Africa. Let me see if I can show off the vaunted speed of SIAC, because I really want to get to the interventions of the panelists, and I'll try to do a quick primer, and maybe the easiest way to do it is put it in the context of the midnight clause, parties attempting to agree on an arbitration agreement. So let's imagine that there's an African party and a party from mainland China. During the negotiation of the arbitration clause, the African party may choose any of the nearly 100 institutions in Africa, many of which are starting to become very prominent. And then the mainland China party would choose one of the mainland Chinese institutions. The advantage that SIAC has for African parties and for parties all around the world is that both sides of a contract, if they can't get their regional choice, tend to be agreeable to SIAC. And this allows you to perhaps get a bit of additional traction on governing law, seat, and some other elements of the contract. So that's been our experience, is that parties are very open to arbitration at SIAC. And as Sukwi mentioned, there's a lot of different ways you can construct an SIAC arbitration, with a seat anywhere in the world in any interaction of the laws that the parties choose. If I was tasked, which I am, to explain the ethos of SIAC's case management, what we try to do is provide the best case management in the world and make it more cost-effective and efficient than any other institution. That's our mandate. That's what we work for every day. We have 6 international arbitration lawyers in the Secretariat. We have international disputes lawyers in our BD department, our overseas offices. This is what we're working for every day. We have more than 1,000 active cases right now at SIAC. We are all international arbitration lawyers that love arbitration and really tried to give customized case management. Whether it's a $2,000 dispute or a USD $7 billion dispute, we are treating all of the cases in the same way. And I think for both Singapore and SIAC, this is why people choose this institution and this destination for arbitration. It's this idea that everything is going to be lily white and the rule of law will be applied without fear or favor. The ultimate test of an institution is that if you're a foreign party and you have a case against a very big Singapore entity, can you come to Singapore and SIAC and get justice? The answer, based on our experience at SIAC, is resoundingly yes. So like every other institution, we have constantly updated our mechanisms and procedures. So we have emergency arbitration, expedited procedure, early dismissal, consolidation, and joinder, ARB, Med-ARB. All of these are designed to really return to the fundamentals of arbitration, to try to make arbitration as efficient as possible. Our experience with virtual hearings, I think, has been a success story for SIAC and for institutions all around the world. The Singapore and the SIAC experience is quite unique because of Singapore's handling of the COVID-19 pandemic. So we've had a mix of virtual hearings, hybrid hearings, and then in-person hearings. What I find very exciting about arbitration as we move out of the pandemic is how we're going to be able to apply those lessons learned during the pandemic, the move to virtual pandemics, and perhaps make arbitrations even more efficient when we can be conducting an arbitration in person. Finally, we know that there's lots of African parties that are involved in investment arbitration. 15% of ICSID cases involve parties from sub-Saharan Africa, and 18% involve parties from the Middle East and Africa. This is particularly topical because we're right now at another session of UNCITRAL Working Group 3. So what SIAC has tried to do is blend its commercial expertise and look at some of the gaps or potential areas in investment arbitration that can be improved. And now we've offered this customized product. So we are delighted to be a part of this session amongst our global experts as panelists, and I will pass it back to my co-moderator, Perry, to start the discussion.
Thank you so much, Kevin. So as you mentioned, it's we're going to go around the world right now, and we'll just kind of take a little bit of time to set the scene for the comparative perspective. So if we could start maybe with Kelvin to give us a brief overview of the arbitration legislation in Singapore and the court systems.
Thanks, Perry and Kevin, and thank you, everyone. It's a great honor to be here at the inaugural SIAC Africa webinar. Singapore is a common law jurisdiction. We have an International Arbitration Act that is modeled after the UNCITRAL model law. And for a long time, we are, of course, a party to the New York Convention. Also, Singapore as a legal system is extremely pro-arbitration. And I have to say that there's an entire ecosystem within Singapore that's been built up to support international arbitration, to serve arbitration users across Asia and beyond. And the courts in particular have been very, very supportive of arbitration. I think in a wide area of different legal issues, the principles of party autonomy and minimal curial intervention, so critical to the smooth running of an arbitration, are very, very rigorously upheld and applied. And so you'll find a consistent trend throughout all jurisprudence in Singapore that supports international arbitration. And not only do we have the courts supporting international arbitration, the ministry as well, the government, is always looking out for ways to improve our legislation to keep a pace with the demands of users. And because of that, we have a wide range of support services for arbitration, like international mediation, third-party funding, you name it, we've got it in terms of a way to support arbitration. So a lot to talk about, but I think let's hear from the rest, Perry. over to you.
That does sound like Singapore. Because we're all common law jurisdictions, maybe we would like to go over to Nigeria. Okay. I understand that Nigeria has a federal law system as well as a state system. So maybe you could explain to all of us who are unfamiliar with the Nigerian laws how this applies to arbitration.
Thanks, Perry. Yes, Nigeria is a federal entity, and so we have a Federal Arbitration Act, which is modeled after ancestral, not yet updated, the model law. There are efforts ongoing. There have been efforts for the last 4 years, not yet successful, to actually have our Arbitration Act updated. States do have the right to have their own arbitration laws. Many states do have, but as a matter of practice, disputants tend to use the Federal Act as their arbitration law that governs the proceedings. Lagos State, though, which is the commercial center for the country, has a very recent arbitration law, which is modeled on the ancestral arbitration law as updated. And so it is more up to date than even the federal legislation. However, you know that it takes a couple of years from when you put an arbitration law in a contract for those disputes to arise. So we have not yet seen disputes that have come up under the arbitration law of Lagos State.
Thank you, Foke.
Sorry,
Kevin. Sorry.
No, I was just gonna say, because this is quite valuable, if you could perhaps indicate any unique features, or if you had to do an elevator pitch for the arbitration ecosystem and the legislation in Nigeria, what would it be for our viewers in Singapore and Asia Pacific?
Well, I think Isaiah would agree with me that we'd both be pitching for the Lagos arbitration law to be the arbitration law of choice.
Yeah. Okay.
It's really modern, it's more up to date. It has ancestral with the various amendments. The federal law is still looking at the old ancestral model law. So I'd be pitching for Lagos.
Yeah.
And if I might just add, I agree entirely with Ms. Adekoya's comments. There is also the River State arbitration law, which is modeled on the Lagos State law, but has additional provisions. So it has emergency arbitration provisions as well. So what we're finding is that the states are far outpacing the federal system as relates to arbitration laws.
Interesting. Thank you. Continuing with the tour, we'll move over to Ruben, who can certainly provide a very good comparative perspective. Could you let us know the legislative state of play in Kenya?
Yeah, in Kenya, which is a common law jurisdiction, we have quite a pro-arbitration judiciary that tries to maintain supportive function to arbitration proceedings and doesn't intervene too much. So the relevant act is the Kenyan Arbitration Act, which actually governs both domestic and international arbitrations. And it upholds the principle of finality in arbitration. There is only recourse to the High Court against an arbitral award for the very limited grounds that mirror those in the ancestral model law. There were two recent cases, Nutu 2 and Synergy, which said that there was further appeal from the High Court, from a High Court decision on the finality of an award to the Court of Appeal, but only in extremely and even more limited circumstances where there was a miscarriage of justice by the High Court, for example. So I would say that the judiciary here in Kenya is extremely supportive of arbitration. There are various efforts that the government is making to ensure that Kenya is a good and preferred seat for arbitration. The Nairobi Center for International Arbitration is one of the centers that we have here. And they've been making lots of efforts towards ensuring that the arbitration law here is updated and useful.
Oh, Very, very interesting. And Madeline, over to Tanzania.
Thank you, Kevin. In Tanzania, we've got an interesting case because we have been under an act or an arbitration act that was passed under colonial times when we were under the rule of the English. And so the parliament then, the colonial parliament, enacted the Arbitration Act of 1931. And that particular act had only one amendment in the 70s and never took form as to the model unicitral model law on international arbitration until just recent, where we've had now a new enacted law that completely repeals and completely overhauls the previous legislation. And this is the Arbitration Act 2020 and a revised edition to that effect of 2020, which was just released. And I just came actually to get hold of it about a week ago, which now is more lucid, more coherent, and more cohesive. And this is coming into force as of 18th January 2021 and has supplementary regulations that are attached to it that came into force in February 2021. So we are just jumping into the ocean. We are very fresh. We're just starting to learn about these complexities in terms of now international arbitration practice as it is now, because we were really just operating under a very antiquated law. Now, we are now aligned to the unicitral model law, 2006 version. We are also borrowing a lot of innovations from the UK Arbitration Act of 1996. And that sort of triggers a lot of questions in practicalities and implementation in the environment that we're set. And then if I could also touch on the fact that, yes, the principles of party autonomy have been enshrined and codified now, the principles of minimal court intervention, where we have a lot of provisions that require leave of the court or permission of the court prior to you doing any maybe appeal on question of law or statement of a case in court. All these require that leave. And so there's that finality. And I heard Ruben speak on in the Kenyan legislation saying that there should be some sort of finality to the arbitral award. Now, we are common law based, as I said, we're under the colonial rule of England. And so we've borrowed a lot. The old regime was also aligned to the precedents or the jurisprudence that was coming out of the English courts. And so the courts traditionally and historically have been pro-arbitration. They have gone over their duty under the previous act to ensure that the principles of party autonomy, the principles or the practice of arbitration is put into play, even though we were under an old act. So that's the thinking coming out of the courts. Now, with this new legislation, we're yet to see. We've got one ruling that was issued sometime in May. Honorable, I appeared before him this morning, Nangela, and Nangela borrows a lot from the English courts when rendering his ruling. And so therefore we feel that we're off to a good start and we're able to leapfrog more like to a position that otherwise we would have been pretty much behind the lines. Then we've got establishment of a new center. Despite the fact that we've had centers around, these centers were just probably, I'm a president of one, but we've just been around. So there's the Tanzania Institute of Arbitrators that has been around for the past 15 years or so. We've got the national construction industry that's been around also for quite a while, and it's the statutory organ. But now we've got the Tanzania Arbitration Center established by the Act. But there's a lot of controversy on how that particular center has been established. And of course, we are party to the New York Convention. And so enforcement of awards has been now codified, because we had signed this in the 1960s, but it has never been domesticated. And now we see it reproduced, or the particular New York Convention articles reproduced under Section 83 of the Arbitration Act, Revised Edition 2020. I think I'll stop there so that we can then go on and discuss further. While we go around the world, that is.
Just one very quick follow-up, mostly for my own edification. So you have brought in an appeal on a point of law from the English Arbitration Act?
Yes, we have. Appeals on point of law have been enshrined into our act now.
Okay, interesting. You know, looking around Asia, when you look at Africa as a continent, because you have common law jurisdictions, civil law jurisdictions, hybrid systems, it's not dissimilar to Asia, where you have Singapore and Malaysia as these pockets of common law. You have lots of civil law jurisdictions, and then more of the hybrid format, say in Myanmar, Philippines, to a certain degree. So you can draw some commonalities. Perry?
Yeah, I agree with that. Also, actually, for my knowledge, I was just wondering how the new arbitration center in Tanzania, how that would kind of sit alongside the older centers.
That's a pretty good question, because under the Act, we are now required to register the particular center. And registering the particular center is through the ministry, where we also are registering through a registrar who's also attached to the Tanzania Arbitration Center. So we're asking ourselves, who are we registering to? Are we registering to the ministry department handling this particular field, or are we registering to the Tanzania Arbitration Center? So there's a bit of a mixed feeling there. As to the neutrality of this Tanzania Arbitration Center, and also to the extent of government involvement in its functions, as outlined in that particular Section 82. So very good and interesting question, but we'll see the play out. We've just had the first round of accreditation, and the two centers that I mentioned have been accredited now. And several, of course, with that accreditation, you also need to accredit your members, meaning the arbitrators themselves. And so that also, that list has also been published as of, I think, on the 28th. And so that brought a lot of confusion. Okay, yes, you under the Act is retrospective. And so whatever arbitration that was pending needs to apply this new Act. And that Act provides that one must be accredited, or else you are criminally liable for conducting that particular arbitral proceeding. And so we've had to either centers not take in cases to administer because they're not accredited, or those who had arbitrations in front of us had to suspend proceedings for fear that there will be a challenge to the award on the basis of that liability under the section. I think it's 88 in the new version, but I beg to differ if I can confirm from the Act.
So we'll just have to wait and see. So I think moving on to Elodie. Elodie, we just wanted to know, you've been based in Asia for more than 15 years now, and you've seen all sorts of cases, and you've been based in Singapore for a long time as well. So what sort of disputes do you see most often?
Hi, thanks. If I look like 15 years back, I haven't seen a major shift in the type of disputes. So I say the one I do, it should be a lot of energy, mining, and in the commercial cases, we always see like the joint venture shareholder disputes. Where I've seen a difference over the years is who the players are, who the users are. 15 years ago, we had a lot of, most of our disputes would be like a claimant would be like a US company, European company suing a counterpart in Asia. Now we see even in large disputes, actually, we're going to have claimants who are going to be Asian companies, conglomerates, who are going to be having disputes against Asian companies, intra-Asia disputes, but also there is outward investment. So increasingly, we're going to see Asian companies like suing Latin America or Africa counterpart. So that's where I've seen the main, more than in the the substance of the disputes or the sectors. I've seen a change in who the users are and the growing role of the Asian users in large-scale disputes.
Perry, I feel almost constrained when we're talking to Elodie, particularly following my discussion of civil law and common law, because that's why Elodie is very popular for SIAC as an arbitrator. And I think that you have rights. I want to say that you have rights of audience in Cambodia. We've had you on a few Cambodian disputes, but sort of taking your Singapore experience, your Southeast Asia experience, and your African experience, and maybe moving to doing business in Africa, particularly East Africa. What are some of the cultural considerations and cultural fluency that's necessary, say, for Asian parties doing business in Africa?
I mean, it's always difficult to generalize. I mean, I think we criticize people when they say Asia, because Asia is very diverse. I think the same can be said about Africa. So I would say, like, I wouldn't generalize. I think what I've seen in arbitrations is maybe like a slightly different style where, again, I don't want to stereotype, but I've experienced African parties being more outright aggressive or open, where an Asian party would be kind of more subtle, but to get the same result. If no is no, it's no. So in the styles, but I haven't. I mean, I've seen the cases I've done. I don't see a major, I mean, again, difference. And as long as the arbitration, I mean, you have kind of an established institution, or like the rules are going to be kind of the same. So I don't see any like, or more like differences than I would see between like Asian parties from civil law background. I mean, if I have a Pakistani party or Indonesian party, it's really different. So in that sense, the cultural differences are kind of inherent to arbitration, and I'm not sure there would be an Asia-Africa divide like this.
Well, there's almost a culture of international arbitration, regardless of parties or civil law, common law, regardless of continent. To a certain degree, people are speaking the same language. Sorry, I heard an observation.
No, I was going to ask if I could jump in, because I have an observation on cultural differences.
Please, yeah.
From the Nigerian perspective, what I have seen are the differences prior to the arbitration process. In that I have seen, and as Elodie said, it's difficult to generalize, but what I have noted is that if you're dealing with usually SOEs coming from China, they are very averse to either litigation or arbitration. And so they will take advice on the disputes. They will take advice on how to start up the arbitration process, what it involves, procedures, how long it's going to take. They take advice even on proposals as to how arbitrators, suggested arbitrators. But they are very unlikely, I have found, to actually commit to entering that process. They would prefer to see if they could mediate the dispute rather than engage in an arbitration process. That's something that I have noted with Chinese SOEs. They would rather end up asking with, when does the statute of limitations run out? Because that then gives them a time frame. And then they'll be asking whether, in spite of the arbitration clause, can we mediate the dispute? And if we can, must it go through the same arbitral body, or could it just be a more informal mediation? So that's where I have seen a cultural difference in terms of Asia, but that's specific to China.
Yes, and if I can chime in there, I actually had a very long conversation with a Chinese client about this, because I noted the same thing, that they are averse to engaging in an adversarial process. They would like to engage in negotiation initially, and then perhaps mediation before they even consider going to arbitration. And I can't pinpoint why, the reason for this cultural difference, but I've noted it as well. Perhaps, they recognize the cost, the escalating cost of arbitrations these days. Perhaps they value the relationship between the parties, or yeah. So I have wondered what the reason for that cultural difference is.
So Isaiah, coming back to you on the counterparties and disputes that you've seen, I think you have some interesting numbers that you wanted to share with us.
Perry, thank you very much indeed. So the trends I've seen are not much related to who the parties are, but more related to how they choose to resolve their disputes. And I think it goes back to the point Kevin made earlier as to the arbitration midnight clause. So from a Nigerian perspective anyway, we tend to see the vast majority of disputes being channeled to ad hoc rather than institutional arbitration. And in this regard, there is a study which I would highly commend to everyone listening, which is the one carried out by SOAS University, Professor Emilia, which we are very proud of and which we continue to support. And what we find from that is that in a given period, there was an institution called, or there is an institution called ICAMA, which is the International Center for Arbitration and Mediation in Abuja. And that center recorded that it administered 165 ad hoc arbitrations. And it doesn't seem like much, but in comparison to the total number of arbitrations administered by 3 institutions in the same period, that amounted to 41. So we're seeing the vast majority of clauses go into ad hoc arbitration rather than institutional arbitration. Why does that matter? Because it now speaks to another trend I've seen. I've seen that in some ad hoc arbitrations, the outcome doesn't match the parties' expectations, particularly as it concerns the costs. So what we've seen, and for instance, we were serving as counsel in 3 related financial transaction arbitrations. And in the first procedural meeting, the proceedings stalled simply because the parties found that the costs were disproportionately high. And they didn't know what those costs would be prior to the first procedural meeting. Now, I've seen another situation where, again, the proceedings stalled and the parties went to court to say, well, we would like to void the arbitration agreement because the cost elements make it impossible for us to perform it. And that hasn't been decided yet, but it is a trend I'm seeing. So how is that relevant? What can be done? I think a lot more conversations need to be had between institutions and the parties to make the cost process more transparent. So in a webinar I was involved in, I did a simple experiment, gave parties, gave the audience a very easy scenario. This is the nature of the dispute. How would you draft your arbitration clause? And the majority said, I would draft an ad hoc arbitration clause with 3 arbitrators. We went through the cost elements and the time elements involved. And immediately, all of them changed their mind to say, I would have an institutional arbitration with the institution that, well, charges the most economically with 1 arbitrator. So I think conversations like this are very useful. I think a lot more needs to be done to make parties aware as to what the implications of choosing a particular dispute resolution path, what that would entail. And I think in the long run, I would like to see a lot more disputes being channeled down institutional routes for reasons which, as we go down the line, I will explain.
That sounds amazing. Maybe we can just switch back to Kelvin for a quick second to tell us about Singaporean investors. So Kelvin, you've been in Singapore for a long time. You've been doing a lot of work with Singaporean investors in Asia as well. What do you think Singapore investors would usually inquire about to ensure that the investments are protected?
Thanks, Perry. I think Singaporean investors looking to invest overseas, they tend to look for systems where they're working with people whom they can trust. I think a lot of it is based on the personal relationships. And sometimes we do wish that they do look more carefully at the macro aspects, for example, as to the legal system they're dealing with and the risks involved. But really it's a more person-to-person sort of a conversation, and they tend to take a lead based on current business trends that they see in the region. So for example, now Africa is something very popular. I think about maybe 2-3 years back, I was giving a talk at the Business Federation in Singapore, and the amount of interest that Africa held for the local audience was really quite astounding, because I think they've gotten a sense from the business community in the wider Southeast Asia and beyond Asia that there's so much opportunity for us to get in there. But if I have a tip to give to Singaporean companies looking to do business overseas, actually, it comes back to the point that Kevin has touched on and Isaiah has touched on. I mean, you can draft your best agreements, your best rights in your contracts, but in the end, your dispute resolution mechanism is what gives life to the rights that you have recorded in your agreements. And if you don't get that right, you are creating problems for yourself. And this tension that we are seeing between ad hoc arbitration, institutional arbitration, is something that I'm quite well familiar with, spending quite a lot of time dealing with India-related disputes. They too grappled for a long time with the entrenched role that ad hoc arbitrations played in their dispute resolution. But they're all coming now round to the view that you need to go with institutional arbitration, because not only do they have the expertise, the means to control costs, they're also probably top the line in terms of best practices, which they'll expect to receive if you go with an institution. So I think there's plenty to discuss, but in terms of tips that I have for Singaporean companies looking to do business in Africa, certainly not leaving the clause to a midnight clause would be a good start.
Thank you, Kelvin. And also because African BITs are also a very, very popular topic now, I was wondering, Elodie, if you have any tips for companies to structure investments for BIT protection.
Yeah, I mean, the tips will be the same for intra-Asia or other investment, but I think if you're looking at investment in a number of countries, and I could say the same about Asia, where there is a risk of political instability, there is a risk of regulatory instability, especially if you have a long-term contract, if you're in a sensitive area like extractive industries. So you may have a contract or you may not have a contract with state-owned entity or the host state. And as Kelvin said, you may have a good arbitration agreement, maybe you don't. So it's always advisable, if you're in such a situation where you have this risk, this exposure, to have a safety net, a second layer of protection, which is investment treaty protection. And for Africa, the difficulty is that a lot of the BITs, there are not that many BITs. For instance, Singapore has like 7 African BITs. A lot of these BITs are not in force. Singapore, out of the 7, only 2 are in force, with Mauritius and Libya. The ones with Kenya, with Tanzania are not in force. So you need to anticipate, which means you need to structure your investments through a special purpose vehicle, typically in a country which has a treaty, and a good treaty, with the African state of your host of your investment. You need to do that exercise, which is permissible as long as the treaty doesn't prevent it, which most treaties don't, and as long as you do it early. You cannot do it when the dispute arises and you're like, oh, I don't have protection, let's do it now. That's considered an abusive process. So we recommend to our client to look at that at the beginning when they are planning the investment, or if we come in later, when to restructure, to incorporate like an SPV in the ownership chain. And I'd say Singapore investors, if you're looking at 2, basically Libya and Mauritius as direct like treaties, you need to think about it and how you're going to channel, like, to give an example, if you take Tanzania, there is no Singapore-Tanzania BIT in force. So you could go and have there is a Tanzania-Mauritius BIT in force, which is a good one. So you could go and put your SPV, Singapore Company Incorporation SPV, in Mauritius, and the investment is channeled, and you have your Mauritius Tanzania BIT protection in place, which, I mean, it's there if you need it someday.
I think that was a very useful tip for a lot of companies and investors out there. Maybe we could also go over now to Madeline, just for to let us know in Tanzania what the up and coming industries are or investments. Sorry, Madeline, you're still on mute.
Apologies. Thank you, Perry, for that, for coming back to me so that I can touch on what is coming up, what is the future for Tanzania. As you know, we've had a change of leadership in March this year, and so she has just concluded 100 days. 100 days, yes, just a few days ago, and so what we're seeing is a different direction, and the doors are opening up to foreign direct investment very much so, by setting now that enabling environment in terms of reassuring the investors of the political stability of Tanzania, and the transition to her being in power is one key factor. And I think Elodie touched on political stability, and Tanzania has that advantage. Now, what is kind of investments in the country that are coming up is that immediately upon coming into power, she signed the East African Crude Oil Pipeline, EACOP. That's 1,445 kilometers of pipeline to transport oil, spanning from Uganda to Tanzania. Now, this is a project that will really be of interest to a lot of practitioners, as it would require a lot of, there'll be subcontractors and main contractors who have already been elected and put in place, but a lot of subcontractors which would require that legal support in terms of setting up either their presence in Tanzania or in Uganda, in the East African region generally. The other initiative, which is an interesting one, is the blue economy. And this is being driven by Zanzibar, Zanzibar and mainland Tanzania, but more so in Zanzibar, where they are encouraging more concepts evolving around usage of the ocean area that surrounds the island and the country for economic development. And so there's a lot of real estate or land legislation that has been that is currently going review to enable either, because in the past all land was held by the president and only citizens or of Tanzania can hold land. But now we're seeing a shift that even foreign investors are able to acquire land in Zanzibar, for example. That's already been put in place, but in the mainland, we're still, deliberating that. Then, of course, top of the agenda is the fourth industrial revolution and digitization. And in her remarks just a couple of weeks ago, she hinted on the fact that our central bank now has to take initiatives to start working on cryptocurrency legislation, or at least a regulatory framework, at least an understanding of it, because we cannot go away with such high rates of using that particular form of exchange. Artificial intelligence, robotics, and the likes, all these have been welcomed within her agenda and strategy for the country. Another plan that has been revived just recently is the Bhagamo Port. And this was on a standstill for about 5 years, but we've seen that construction and infrastructure is a key agenda to enable development of the country to move forward in terms of its ranking on economic basis. And I think those are the key areas that I would like to highlight that are upcoming industries, or at least investments within Tanzania. And I think it's generally even for the region. Of course, I didn't touch on mining and energy because that is well known. What we're seeing is that in the mining industry is the nickel projects are also being revived. These had come to a halt because of infrastructure problems. And, nickel has to be transported, and that kind of transportation line was not present. But with this new agenda, working on infrastructure, it will enable even the nickel projects to now pick up pace and start generating nickel and from the country.
I think for my part, institutions are always very interested in up and coming sectors, industries, jurisdictions. Do any of the other panelists want to provide their observations, whether in their practice overall or in their primary jurisdiction? What kind of disputes they're now seeing the most of?
Kevin, could I quickly jump in?
Please, yeah.
Sure. So just picking up from where Madeline left off, I think one survey I would commend is the one carried out by a group called the Africa Private Equity and Venture Capital Association. And what they've done is they carried out a survey to see what are the most promising sectors for investments. And the top four are healthcare and life sciences, very important in the current landscape, technology, again, for obvious reasons, agribusiness, and financial services. And certainly from a Nigerian perspective, financial services and fintech is an area that is doing extremely well. Going back to the survey, number 6 on the list of promising sectors is infrastructure. And my suspicion is that that will gradually climb up the list in the coming years, principally because of the Africa Continental Free Trade Agreement. And there is a growing conversation as to whether, in order to make the most of AFCFTA, we certainly need a massive investment in infrastructure development, because to facilitate these trades, we need infrastructure, like Madeline said, to be able to, for instance, move that nickel from Tanzania to Lagos, for instance. So I suspect in the coming years, as AFCFTA kicks in, infrastructure is going to be another area which is already doing well, but I think will pick up even more. But certainly the fintechs, technology-related, healthcare, agriculture, those are doing very well.
Can I add my tuppence to Isaiah? I agree with him 100%. I think that the survey, which I also agree with, but I think it was focused more from the perspective of the owners of the survey, which is private equity. And I think that's why infrastructure came in at number 6. Infrastructure, at least in Nigeria, seems to be more government to government in terms of usually China and some other countries sponsoring and building that infrastructure. But that is moving as the government is now considering concessions and concessioning public institutions like our airports. I think that infrastructure construction is going to rapidly move, if not to number 2, to number 1. I also think that there would be, from what I'm seeing within the Nigerian market, I also think that real estate development is also going to be a flashpoint. In Nigeria, at least, there is a need for more housing. And at this point in time, government cannot provide enough housing, even social housing. A lot of private developers are going into this space. It might come up by way of joint venture shareholder disputes or funding disputes. But I have seen some arbitration disputes coming up in the sector of real estate development, residential developments.
Thank you. Ruben, any comments from the Kenya perspective?
Sorry, mute. I think in Kenya, we've the dispute that we've seen an increase of, particularly in the pandemic year, has been contractual. In terms of infrastructure and the observations that both Isaiah and Funke have made, there is a new project called Konza Technopolis, and I think discussions have shown that there will be an increase in disputes relating to infrastructure, construction, coming out of this project. It's meant to be, it's a vision for tech city and integrated sort of satellite city. And I think that will be a source of dispute in the coming months.
In terms of the project cycle, do you find that broadly that these major projects are coming to the dispute phase within the next months, years? Where exactly are we in the project cycle for disputes?
I would say that there are a bunch of Chinese projects, again, for integrated, construction, residential, office, and healthcare, all of that in one place. Some of those have, I would say, already reached dispute stage, because the construction has happened, delays have happened. Whereas with Konza, it's very nascent and has not reached dispute stage yet.
Interesting, thank you. Perry?
So I think something interesting that was brought up was also the idea of sustainability and also Bitcoin technology, so fintech technology. I think in Singapore, some of our local firms have started like ESG departments and are looking to give more advice on these industries. So Kelvin, I was wondering, is this some kind of, are these disputes things that you see coming up as well?
Thanks, Perry. Certainly in the space of cryptocurrencies, we've seen a good number of cases now and before the courts. And I think very recently there was a very leading decision issued by the Singapore International Commercial Court that gave some interesting guidance as to how you should treat cryptocurrencies. I mean, do you treat it as an asset class, right? What rights attach to something as new as that in a commercial space, and to what extent do you draw analogies with the more traditional categories of asset classes that the law is more accustomed to dealing with? So certainly cryptocurrencies, I think it's a hot area. I think just looking at the sort of cases that we have been asked to consider in the firm, there's certainly an increased uptake. No least also because of the volatility that you've seen in some of the prices that you've seen recently. But in whether these disputes go to arbitration, interestingly enough, just maybe about a month back, I was actually engaged on a case where it is alleged that there has been some misappropriation of cryptocurrencies, and is a case that's ongoing now, and we'll see how that goes. So certainly for cryptocurrencies, it's a big area. For ESG, I think that's a big area in the legal sector now in Singapore. But it is fair to say, I think that a lot of the focus at this point in time is directed towards the finance sector as well as the regulatory space. I do think that the disputes concerning environment and governance issues that we see in ESG space would come on stream in due course. Certainly with all the concerns about how the environment is being treated, the recent discussion whether you recognize ecocide, for example, I think the more these topics gain currency, I think we will see a lot more of that coming our way. And I think SIAC have a big part to play in that journey.
Thank you, Kelvin. I think I just also wanted to move on to discuss some of the challenges that you face when participating in arbitrations in Nigeria or in Kenya or in Tanzania, even in Singapore, or anywhere in the world. And I was wondering, Isaiah, if I could turn to you first. What are some of the challenges that you have faced while participating in arbitrations?
Thank you very much, Perry. I think for me, the biggest challenge relates to the enforcement phase or the challenge phase, specifically the time concerned in making those challenge and enforcement applications. And let me sort of boil this down into figures. What we did really recently was we undertook an internal review of each published arbitration-related decision in the Nigerian courts. And we did that to see, well, what are the proportions of, for instance, agreements that are enforced, challenges that are upheld, etc. Now, as it relates to the time, we find that the higher up the hierarchy you go, the longer it takes. So we saw that, for instance, for a challenge application in the High Court, 41% of the time it will take less than a year. Whereas if you go to the Supreme Court, it's only 6% that will be resolved within a year. So in the Supreme Court, 68% will take you more than 3 years. In a court of appeal, 46% will take you more than 3 years. Now, the good thing is, now that we have these figures, we can make use of them. So never waste a crisis, or never waste some useful numbers, right? So there has been conversation as to how do we mitigate this. So several ideas came through, and I think Mrs. Adekoya was part of the conversation when the review process of the Arbitration and Conciliation Act was in process. One of the conversations was, well, do we introduce time limits for arbitration-related applications? And the ideal scenario then would have been to embed time limits in the Constitution, as has been done with, for instance, election-related proceedings. Another conversation was, well, do we either limit the appeal level to which arbitration-related cases go? So do we stop it at the Court of Appeal? Or conversely, do we start at the Court of Appeal, then go to the Supreme Court? Again, that would take constitutional amendments, which is not an easy process in Nigeria. But the good thing is we are aware of this. It's a problem, and we can at least take measures to share this information with the courts, tell them why it's a problem, in the hope that they will, for instance, introduce practice directions, rule changes within their respective jurisdictions to facilitate and fast track these arbitration-related applications. But let me also give some good news in terms of what good news did the figures show us? Well, they show us that, and this is going full circle to the first question you asked, what's the legal system and how does it support the arbitration process? Well, what we're finding is that the figures support the pro-arbitration nature of the Supreme Court's pronouncements. And what I mean by that is the Supreme Court has said that the appropriate review standard is one that maintains party autonomy and minimizes judicial intervention. So when you translate that to enforcement applications, for instance, we see that 75% of enforcement applications are granted. And likewise, 78% of challenge applications are refused. So at least from a numbers perspective, it's telling us that, yes, we are an arbitration-friendly jurisdiction, but we do need to work on the time it takes from getting to that award to enforcing it.
Thank you, Isaiah. So I suppose there's always something to work on. Funke, how about you? What sort of challenges do you face when participating in arbitrations?
My major challenge has been something that Isaiah had referred to earlier on, which is the conflict between ad hoc and institutional. As counsel, I have found it difficult to persuade parties to have an institutional arbitrational clause in their agreements. And they talk about the costs. And they talk about party autonomy. We'd like to be able to appoint our own arbitrators, and we understand that we own the process, and institutional arbitration takes it all away. And someone, invariably, they say, sits in Paris or in Geneva and determines whether or not to accept our nominees. That's my major challenge as counsel. My major challenge as arbitrator, still the same thing, ad hoc against institutional. Ad hoc, I'm chasing parties to pay, which is always a problem. I'm chasing administrative decisions, sorting out whether procedural orders have been served and things like that. I'd go for our institutional arbitration any day, dependent on cost. If there's anything that SIAC can do to support this view in the Nigerian space, I'm ready and able and willing.
I think if I can chime in there, I think there's a real range in terms of the sophistication of parties in an arbitration in Africa. There's the parties that have counsel and appoint lawyers who treat arbitration very much like a litigation, and you know, act in that way in terms of their submissions. So in instances where I've assisted an arbitrator as a secretary, or simply assisted John Miles, who is the managing director of J. Miles & Co. In these arbitrations, we find that submissions by parties can be, you know, extremely litigious, dealing with it as if they were in front of a court. And then on the other end, you have parties that are extremely sophisticated and understand the difference between ad hoc and institutional arbitrations, and are able to appoint arbitrators who have knowledge of the continent, of how business works on the continent, while still, you know, having knowledge of whatever law it is that governs that contract. So there is a range, and it's interesting, I guess, to see how that will change. I think one of the challenges that I have faced in participating in arbitrations is that the issue of capacity in our local council when dealing with arbitrations. Again, a range. There are great and amazing local lawyers who understand how arbitration works, and then there are those that don't. And then bridging that gap and building that capacity, I think there's been a range of policy from both the Attorney General's chambers in Kenya. For example, in a recent exit case that they did, had insisted on assisting international counsel, who often I find in these investor state disputes do take lead counsel role. But one of the policies that the Attorney General's chambers here in Kenya has tried to implement is that it has to be jointly done by both local counsel in the Attorney General's chambers as well as international counsel. And I think efforts like that really help to build the capacity locally, specifically in investor state disputes, which don't always come by, and in which that, you know, prior knowledge and prior expertise and experience is really, you know, extremely useful.
I'm looking at the Q&A, and we're very fortunate because our panelists have been answering questions along the way, but I'm also mindful of the time. So if there's any questions for our panelists before we have to let them go, and while we're waiting for any of those questions, any concluding thoughts from the panelists on the future of arbitration, not just in your jurisdictions, but as we move out of the COVID-19 pandemic?
I think there's going to be greater cooperation between East and West. And that's why I like the idea of this webinar. I think there's going to be more investment coming into the African continent from Asia in all aspects: India, Korea, Japan, China. And so I think there's also going to be a focus, Africa moving away from its traditional investment partners, Europe, England, America, and moving towards Asia. And so I think cooperation between arbitral institutions on the Asian continent and on the African continent is a great idea, and where we can help ourselves and promote a dispute resolution system that works for both sides, then I think we'd have achieved the reason for being on the African Users Council of SIAC.
Yes, if I may just jump in, Kevin, I'll just echo what Funke said. I think collaboration across borders is really the way that we have to work in the future. And really the advent of technology, as Xiaopui mentioned at the start of this webinar, has truly broken down those barriers. And in one area, I think international arbitration has to adapt is the fact that users these days may not be prepared for a very long drawn dispute resolution process that's open-ended. And there's a great need now for us to respond by ensuring that first we keep proceedings efficient and predictable while maintaining flexibility in how we go about resolving disputes. there's also a need to, I suppose, ensure that arbitration is open to other ADR processes working alongside arbitration, so parties can seek to resolve the disputes on the side as well. And I think the SIAC, SIMC, ART protocol, it goes a long way towards fostering the sort of cross-collaboration across ADR platforms. And I think the way we can propagate this way of thinking is to hold more of these webinars, basically, to share information, to capacity build, as Ruben mentioned. And that is really my hope in the coming months and years, that we will see a greater collaboration across borders to build really a system that could best serve the needs and challenges of the clients in this challenging environment.
This was something, Kelvin, that we were talking about the other day, this unique procedure that SIAC has with the Singapore International Mediation Center. And we've certainly seen great success with it, because when you start an arbitration and go to mediation, you don't necessarily have to come to a mediated agreement. You could agree on a few heads of claim, then go back with a more streamlined case to arbitration, but there's a very good success rate anyways. It's a very low risk option for parties to take. And Funke, I should say, from the ad hoc versus institutional arbitration standpoint, for when you're an arbitrator in an ad hoc proceeding, we do offer fund holding services, but perhaps what we should be communicating to parties on the continent is the average time of institutional arbitrations at SIAC, less than a year overall. You're looking at maybe 9 to 12 months for a sole arbitrator procedure, around 14 months for 3 members. So the timelines in institutional arbitration and the costs quantifiably are quite good. Perry?
So I think that's all the time we have today. And there are no more questions left in the box, because thank you, panelists, for typing in the answers as we've been going along. If there are no more concluding remarks, I would just like to take the opportunity to thank everyone here for joining us today. We were so happy to have you, and we hope to do so much more with you. Thank you also to all our viewers who have joined us today from all over the world. We are so grateful to have you. So thank you once again. Thank you.